Hello. Welcome to this week's Private Funds Update. I'm Sandra from SmartEsq. Here's what I learned this week. We begin with the SEC's continued offensive on liability waivers. In orders released earlier this week, the Commission settled charges against two investment advisors regarding the use of hedge clauses in retail agreements. The SEC found that these firms violated the Advisors Act by using clauses that purported to waive liability for anything short of gross negligence. Crucially, the Commission rejected the defense that the agreements contained savings clauses, that is, fine print stating that non-waivable rights under federal law still apply. The SEC's position is that for retail clients, the hedge clause itself is inherently misleading because it suggests a waiver of fiduciary duty that doesn't exist. If you serve retail clients, review your standard terms because similar savings clause defense is officially dead. Turning to real estate. On January 20th, President Trump signed the executive order titled Stopping Wall Street from Competing with Main Street Homebuyers. Contrary to some initial headlines, this order does not impose an immediate ban. Instead, it directs federal agencies, specifically HUD, the FHFA, and the Treasury, to issue guidance within the next 90 to 120 days. The directive instructs these agencies to prioritize individual homebuyers and nonprofits when selling homes from federal inventories, effectively ending the first look programs often utilized by institutional aggregators. It also mandates a study on how federal financing supports large institutional investors. While the sales haven't stopped today, the regulatory writing is on the wall. The pipeline of government-owned distressed inventory is closing for private funds. Next, to the Supreme Court. The justices have agreed to hear an appeal from former Intel Corporation employees who are challenging dismissal of their breach of fiduciary duty claims brought under ERISA. This case returns to the High Court to address a critical circuit split regarding pleading standards for excessive fee and performance claims. The core question is, what must a plaintiff plead to survive a motion to dismiss? The Ninth Circuit previously allowed claims to proceed based on simple comparisons, such as alleging a fund had higher fees than a cheaper index fund. Intel argues that this is insufficient, and that plaintiffs must provide a meaningful benchmark, an apples-to-apples comparison of services and strategies, before dragging a plan sponsor into discovery. A ruling for Intel would significantly raise the bar for plaintiffs, curbing the flood of stock drop and excessive fee litigation. Conversely, if the Supreme Court rejects the meaningful benchmark requirement, it could open the door to increased ERISA litigation. Finally, digital assets. The SEC's Division of Examinations has issued a new risk alert regarding tokenized securities. The staff clarified that to satisfy the custody role, a qualified custodian must demonstrate exclusive control over the private keys. The alert explicitly warns that if an advisor or any non-qualified third party retains even a shard of a key that allows them to unilaterally transfer assets, the qualified custodian requirement is failed. That's it for this week. You can learn more about these topics from me on the SmartEsq platform. If you are curious about the services we offer, please visit www.smartesq.ai.